Hi everyone, and welcome to our week 4 lecture, and I hope you are enjoying the course so far. For this week we have the topic of arbitration, and we also make a transition this week into our new text. We incorporate the second text that we have for this class, the Najida text. And we will be covering chapter 1 of that text, which kind of introduces collective bargaining. So let's talk a little bit about arbitration. So what is arbitration? Okay, when we think about arbitration, the first thing that should come to mind is the concept of the word arbiter, right? An arbiter. And what is an arbiter? Well, an arbiter is nothing more than a referee, okay? And so in essence, the concept and the process of arbitration is nothing more than having a referee, a third party, decide a dispute or a problem that cannot be decided by the parties themselves. Arbitration can be both contractual, it can also be required, mandatory, and it can also be voluntary. And we'll see that here in a minute. But arbitration is contractual, not statutory. So there is no, it is not driven by law, essentially. It's contractual in the sense that parties agree to enter into the arbitration process. It's generally informal, meaning that it doesn't require, say, a formal process of a legal process, a process of having to go to court or having to have a judge present and that kind of thing. But it can be very informal in that respect, where parties can negotiate and express themselves and make their cases and positions known to the arbiter in an informal manner. Parties usually select the arbitrator, and this is also part of the process and the informality of the process of arbitration. Of course, it's not always considered something that's 100% fair, because sometimes a party that has an advantage over another party, perhaps it's a financial advantage, maybe deeper pockets, may have a better chance at choosing somebody that they have worked with before and that they feel confident with, and perhaps there might be some bias in the process. So this is something that comes with the territory, so to speak. But in general, parties choose and select the arbitrator, and they obviously have to agree, both have to agree on the arbitrator. And they also have to agree that the arbitrator is the one that's going to make the decisions. So arbitration requires agreement by both parties that the decision to be made will be made by that third person. And you have to, once you agree to the arbitration, you agree to the outcome for all intents and purposes, right? Power imbalances is equalized in arbitration. The power imbalance is equalized, and that's one of the purposes of arbitration. You're trying to have two parties with different positions and needs and expectations and desires. You're trying to balance out the power, and when you find that there is no way to get that, to achieve that goal, that outcome, you seek the services of an arbitrator, an arbitrator, to help you balance that power. And then lastly, arbitration produces finality in issues, which means that arbitration is intended to produce an end result. It's intended to come to some agreement, to solve the problem, reduce or eliminate the stalemate, right? So that's the real goal and objective of arbitration, is to produce a final outcome that both parties can agree to. When should arbitration occur? Why should we use arbitration in decisions to solve problems? Right? When is it best? Well, obviously, when parties find themselves in a deadlock, right, in a stalemate where they simply cannot resolve their differences after mediation or negotiation has taken place, or at least the intention for negotiation or mediation has failed to produce a result that both parties agree to, then that's when arbitration comes in handy, right? Also, one situation where arbitration is kind of the good way to go is when relationship is not so important. And what does this mean? Well, it means that when two parties, especially parties that are negotiating, say, contracts or dividing up assets or disputing over a resolution or some sort, relationships tend to be important, meaning what's going to happen afterwards, right? What's going to happen once this dispute is solved? How is that going to affect the party going forward? When relationships are not important or not that important, arbitration becomes a much more feasible solution, because you really don't, for lack of a better term, you really don't care what happens afterwards. You're not going to have a relationship with the other party, and so it doesn't really matter what the other party feels or thinks of you going forward, right? So that this is one situation where arbitration might work. Okay, legal issues predominate. Okay, so when there's a legal dispute, right, and both parties essentially have a legal claim, then they both might be very, very stern in holding their positions, right? And so you need that third party, that arbiter, to come in and say, okay, this is that you both have a claim, but this is the fair way that we're going to distribute these assets, for example, and this is my decision, and you're going to have to live with that. Okay? Sometimes there's a history of acting in bad faith, and when such a situation arises, you might seek the services of that third party to help with the trust issue, right? When you don't trust the other party, you seek an arbiter to come in and make that decision for you, because that's usually going to give you a much more confidence in the process. And then lastly, when there is a need for an immediate decision, because as we'll see here very shortly, arbitration, one of the pros of arbitration, one of the benefits of arbitration is that it can be very expeditious, right? It's a very quick, relatively quick process that is preferred to, say, for example, going to court, going to trial, which can be dragged forever, right? So some of the characteristics of arbitration. Well, we said, right, arbitration can be voluntary or mandatory. Voluntary, usually, say, for example, a husband and a wife are getting a divorce, and unfortunately, right, and so they have no choice. There's no way that they can resolve their disputes as far as who gets what, and what requirements are going to have to be met by one party versus the other, etc. So in this case, both parties might say, you know what, for the benefit and for the sake of the children, for example, let's try and work out our differences in a cordial and civil way. And so they might voluntarily seek the services of an arbitrator to help them resolve their differences. So this is one type of voluntary arbitration. Sometimes, and this happens in especially with contracts, might stipulate mandatory arbitration if certain disputes cannot be resolved among the parties. And so this would be mandatory arbitration. Arbitration occurs in phases. So you can read about this in the book, in the book that in chapter 6, I believe. You can read about it. But basically, you have the beginning of the arbitration phase where you you kind of agree on the process. Then you choose an arbitrator. Then you choose the time and the manner and how the process is going to flow. You decide who's going to represent. All of these different phases that go into the process, and then of course the actual meetings that have to take place for the arbitration process, and then how the arbitrator is going to make the decisions, and then lastly when the decision is made, and then of course the execution of the decision, meaning who gets what, and how the assets are going to be distributed, or how things are going to be paid, or whatever the result may be. So arbitration occurs in phases. Their arbitration is private, and that's one of the big advantages. You can resolve problems that could kind of get out of your hand, right? Get out of your hands and become public. Many folks, whether private or firms or even the government, sometimes wishes not to have certain issues or certain conflicts or concerns come out and become public, because there is a risk that these will have a further impact, a future impact down the road. There's also the image risk, right? You don't want to hamper your image, and so you'd rather keep some of these proceedings private, and that's one of the benefits that arbitration provides. And again, as we said before, it's informal. You don't have the formalities that go into a lawsuit and a case and a hearing and all of those legal requirements that are associated with going to court. So just again, some of the pros and cons of arbitration. Arbitration is faster. It's more. It's a faster process because again, it doesn't require all of the legal proceedings. It's usually more cost efficient because you don't have you don't have to have a lawyer. Generally speaking, you will have a lawyer if you're a firm or the government or if there's a lot of money or assets at stake. Sure, you might seek some legal counsel, but you don't have to, and so it can be much more cost efficient. Two people can resolve an issue by themselves if they just agree to an arbitrator. There's the issue of finality, right? So our arbitration's got a purpose, and the purpose is to find a solution, and that's going to happen. Arbitration seldom leaves things just unresolved. There is a finality to it, and that's something that's desired by the parties. You also have relaxed rules of evidence, right? You don't need to have the legal rules of what can constitute evidence and what is not evidence. All of the legal stuff that you would normally have in a legal case, you don't have in arbitration. It's very relaxed, and there's many things that would not be considered in a case, in a legal case, in a formal case, that are considered in arbitration processes. And then lastly, you have expert arbitrators. These folks that are arbitrators know what they're doing. They become very good at it, and so they know how to negotiate. They know how to mediate. They know how to talk to people, and they've kind of been around, and they've seen many types of situations, and so they become very good at trying to get people to agree, and then also providing a solution that's going to be fair and equitable for those parties. But it's not always perfect, and there are cons to arbitration. You can have biased arbitrators, right? Especially those that maybe are are found or paid for by a firm or a party that has a lot of money, right? Deeper pockets usually leads to some kind of a biased arbitrator. Sometimes forcing arbitration in and of itself is a problem, because once you force arbitration, you're kind of forcing somebody to agree on a solution when they really didn't want to agree on the solution. So right out of the gate, it's going to be something that's not going to end up being a desired solution. Then there's this issue of limited discovery. In formal cases, you can have ample opportunity to provide evidence and facts and things that will prove your points and your positions. But in arbitration, there is a limit to what the time and the amount of evidence and of support that can be provided to support your position. And this is part of the arbitrator who will place limits on how much and how long people have to prove their position and to show what they want, right? So there's limited discovery. And then these other ones, right? Arbitrators get paid by the hour. It's not. It can be, even though it's probably less costly than a legal proceeding, but it can also be costly because you're paying by the hour, right? And you have to meet a lot of time. There's a lot of time that has to go into meeting and talking to lawyers or to the arbitrator, and so it can accumulate, right? And then you can end up with inconsistent outcomes in the final decision of the arbitrator, something that you may find unfair. And then the loss of upside, and this is a big one, right? Where if you have an advantage, because arbitration seeks to balance out the power, you end up kind of losing that advantage, that upside that you would have normally had if you had gone a different route. Arbitration leaves the decision up to a third party, and that third party may have may have a vested interest in finding the most equitable solution, but that equitable solution may not necessarily take into consideration your advantages, right, or your upside. Okay, so that's arbitration, and that is our chapter 6 from the first text. And now we introduce our second text, and this is the Najida and Stern collective bargaining in the public sector text. Okay, and so a little bit of a change in course here, and we are going to look at chapter 1 of this text, which kind of introduces collective bargaining to us. And what is collective bargaining? Well, collective bargaining is the concept describes the process of negotiation between employers and a group of employees, and the aim is to agree on things like salaries, on hours, working conditions, benefits, and any other aspect that might apply to employment, right? To the workers' employment conditions, etc. So that's kind of what collective bargaining is. And collective bargaining can be either narrowly defined or broadly defined, as the text, chapter 1 of this text, explains or illustrates different examples of collective bargaining from different states of the United States of America. And it shows how in some states the legislation for collective bargaining is narrowly defined, and in some states it is broadly defined. For example, in the state of Pennsylvania, Pennsylvania provides for parties to meet and confer with respect to hours and other conditions of employment. Very broadly defined, okay? Conversely, New Jersey and Illinois, you have, for example, in New Jersey, you have the Supreme Court of New Jersey determining that the employees, public employees, do not have or did not have the right to strike unless they had an explicit grant allowing them to. So this is pretty narrow. Illinois, for example, in Illinois, police, fire, and correctional employees are prohibited from striking. Other employees must meet statutory prerequisites to strike. So you can see, for example, that in some states like Pennsylvania, it's broad, and in other states like New Jersey and Illinois, it's narrow. There's also a challenge of collective bargaining between on account of federalism, right? Federalism, remember, is the system of the United States government that has power being divided and shared between the federal, state, and local governments. But specifically between federal and states, right? Collective bargaining is challenged because you have the federal rights, right? The federal legislation versus state rights, and we see that in for example, in the right to strike, right? If you look at the right to strike, federal sector prohibits strikes unless explicitly authorized by statute. Okay, but then, so how does that limit the state's rights to determine whether they want to allow their workers to strike in their state, right? And so there's this sometimes this dispute or disagreement between whether workers, public sector workers, have the right to strike or not, right? And in what way is it, are you as a worker being protected by the federal Constitution, the U.S. Constitution, and to what extent you are protected by the state rights, right, and the state constitutions. So there is kind of that discrepancy in some ways. So the right to strike, right? What is the right to strike? Well, it's the right to go on strike, right? We know that that striking or going on strike is a mechanism to bring finality to a bargaining problem. Okay, we see this very common in the private sector. In the public sector, not as common because of the limitations, right? And it's in the fact that it's prohibited in many states, allowed in others. In fact, at least 14 states allow it. But the fact that it is prohibited makes it much more common in the private sector, and in the private sector, it usually will lead to a finality because firms cannot continue to operate without their workers, right? So at some point they have to come to some kind of an agreement. But with the federal government or with the states, it depends, right? To what extent should you allow workers to strike, and is it fair and even constitutional to prohibit them from striking? And sometimes, in most cases, the nature and justification for striking is what makes the difference, right? You have to have a reason that's a valid reason to strike, so that the state can defend that right to strike it. And it has to be a situation where you're striking because you seek a remedy that is violating your rights, not just using it as a tool to take advantage of your labor power to get, for example, higher wages from the government. Okay, so there has to be a justified reason for striking. And of course, we know that striking and strikes historically have been seen as negative. They are not desirable, right? Nobody wants to go on the picket line. Nobody wants to strike. It's not good for the firm or for the employer, and it's not good for the employee. And so there's preferred solutions. There's preferred solutions to striking. And these solutions are mediation. Then there's compulsory arbitration, which is arbitration that provides parties with a procedure for a final resolution to their disputes that usually arises from some alleged violation of terms and conditions for employment, for example. Then you have conventional arbitration, which is your standard third-party arbitrator, where that third party is hired to resolve and to make the decisions for the two parties. And then there's grievance arbitration that usually grievance arbitration has to do with some kind of a harm that has been done to one of the parties. Okay, so this is what we had for this week. Our two main topics discussed for this week are arbitration and collective bargaining. Please read your those two chapters, chapter 6 in our first text and chapter 1 in our second text, and have fun for this week. I hope you enjoy the lecture. I hope you enjoy these topics, and God bless you and take care. Thank you.